Okay. So this person sat in the courtroom when I was arguing the Tokubaku case about the Charlotte Osei matter. And I told the judges that you are all endangered if you don't provide rules to state what exactly is stated misbehavior, because she has breached a procurement process. Why don't you use a different way rather than remove her? Yes, Mame, were these matters too not worthy?
Thank you, Samson. Let me start with a quick comment on the separate actors in this saga. I'd like to first commend the President on having respected the Constitution and the Constitutional Court in the process. But I'd also like to commend him for having had the statesmanly prudence to refrain from speaking on the matter in public during its pendency. I mean, there were no sensational press conferences and no one considered interviews from his spokespersons of office or his office. I take that to mean that our leader appreciates the gravity of what he has just done. I want to comment on the removed CJ, and I wish she had shown as much deference for the Constitution in the process and not held the press conference that she held. I think whatever the strength of her concerns, the use of the press conference to air them was not the appropriate forum, and as the head of the judiciary, she should have demonstrated faith in the Constitutional Court and limited her public engagement to the court processes. So, with respect to what's...
Will you be surprised, Mame? Will you be surprised that what you just said was actually used against her in the address of the petitioner? They used it against her, that she went public to say things and try to get public sympathy against the committee, and they quote things where she herself is heard saying that the committee has been generous to her, and they say she didn't tell the public all of that. Then they say the committee said it was an inquiry, but she told the public that the committee disagrees that it was an inquiry, when the committee had actually said it was an inquiry. And they say all sorts of things. Some of them, I think, a bit, you may say trivial, that she got angry, stormed out of the place, and so on and so forth.
I think, as I said earlier, if everybody had respected the in-camera requirements, there would be a different tenor to the process. And the former Chief Justice, did not lead well on that front. That should not have been the forum. In respect of what Justice Sophia Kufu said, I understand her to mean that, I understand her not to mean that a CJ should be able to behave improperly without repercussions, but that the constitutional processes upon which the distribution of power rests in our state are so weighty and they so reverberate through the legal order that we must hasten slowly to trigger them. In that, she is right. The appointment and removal of the heads of the arms of government are constitutionally foundational matters. Removing a tumor can save your life, but it might also leave you paralyzed, or you must have to learn how to speak again, or learn how to use your arm again. So we should be mindful that even a good outcome in these kinds of foundational matters leave unintended consequences and have impact that we should be very mindful about intentionally addressing. Where I disagree respectfully with my lady is that the matters established are not weighty enough to merit removal. As Oliver said, the committee's question was not, are they weighty enough to merit removal? It was, are they proved? That question, are they weighty enough, was put to the Council of State. And the Council of State said yes. I have issues with how the Council of State came to have the say in this matter, because the Constitution originally does not include the Council of State, but that's a separate matter for a separate day. I think that even aside from the Council of State having said yes, I personally think that the legitimacy of the legal order rests on the people's perception of the judiciary, and therefore judges have a duty to hold themselves to the highest standards of integrity. Virtue signaling is really important for the maintenance of a constitutional order. It's as important as the use of the actual judicial power. So, for instance, when you are studying for an exam, you get a certain comfort from being advised by the best student in the subject. So much so that when contrary advice is given by the worst student in the subject, even when that advice sounds more correct to your ears, you are very hesitant to take it. And that is the role of the personal conduct of a judge on the legitimacy of a system. So, if it is really important that the head of the judiciary virtue signals. There is, after all, no connection between the legal and philosophical soundness of a judge's decision and the moves they were making in a club the previous Friday. But none of us would want to walk into a courtroom and find the super flexible dancer from the club last Friday behind the gavel. In like manner, the CJ should be held to the highest standards. And she is human. Everybody is. There will be errors. There will be mistakes. But they should be such that they should be open to an interpretation of good faith error. So if the Council of State has found that these matters are weighty enough to remove a CJ over, I think, like Oliver says, it is a statement about what we expect the standards of integrity of our public officers to be. And I think the committee's job was not to investigate whether the council was right to say so or not.
For Justice Sophia Akuffo, she had been consistent, we will say, because she doesn't agree that there should even have been a prima facie in the first place. And then she comes now, after it was done, we get to know that she goes to testify, for the Chief Justice. She, together with other friends, go to testify for the Chief Justice. So her position is one of consistency.
And this is one of the things I admire about Justice Akuffo. She is consistent. If she takes a position, she thinks it through and she stands by it. And I respect that in a judge.
Right.
I do, however, disagree on this in this instance.
The question people are asking, the question people are asking, which I want to ask you is she not entitled to change her mind? If you say that in Charlotte Osei's case, she's the one who found prima facie, and it was about procurement. You say this one, for example, the financial impropriety charge. It is a matter for audit and the finance people, and even if it was flagged, she could just repay or refund and move on, instead of using that to remove her. Is she not entitled to change her mind that in this case, I found prima facie and it led to the removal of Charlotte Osei, but now I reflect. And you see that anytime she talks, she's reflecting on Article 146. That something ought to be done.
I'm a legal theorist, and I would be remiss to say a person must stand by a position they took even after they've evolved. So I don't necessarily find it odd that I have taken positions that I have later resiled from. I do think that intellectual honesty requires you to admit that you have resiled from a position rather than present it as a position you've always had. So if Justice Akuffo has reflected further and has changed her mind, I'm not sure why she's not entitled to do so. Any more than I don't know why I wouldn't be allowed to disagree with her on this one.
So it would be unfair for those who suggest that she's being dishonest.
I mean, to the extent that she admits that she has taken a position on reflection and has results from the original position, I think the whole point, I mean, there was a time when slavery was right, and then there's a time when we soundly saw that it was wrong. The problem is if we pretend we never had slavery, we never thought it was right. So I haven't myself read Justice Akuffo's statement. I cannot say, therefore, whether it is it falls in the line of the methodology I think an intellectual should use to evolve.
Okay.
But I can't say that the fact of evolution is not wrong.
All right.
Whether this particular instance meets it or not, I am not in a position to say because I haven't actually read the statement.
She actually uses the term de minimis. The courts do not concern themselves with trifles. This is what it was. But this thing that people are bringing up is the reason I remember that she used the Latin expression de minimis. That she's been removed as CJ, but not removed as a justice of the Supreme Court. What do you say to it?
I think the removal of a CJ for stated misbehavior would have to meet a threshold of stated misbehavior for a Supreme Court judge. So, first of all, I have seen the deed. The president has removed her as both, but I think it would be odd to say that misbehavior that meets the threshold for the removal of the Chief Justice somehow does not meet the threshold of misconduct for a Supreme Court judge. The specific instances are administrative things, so they're not matters that a Supreme Court judge ordinarily has to deal with. But the question I would ask is, if we were to say that it was not sufficient for removal, right? These are not weighty matters. Then, if other people come before the courts on financial misconduct matters, misappropriation, embezzlement, and so on, would we be able to impanel a Chief Justice who has been removed from Chief Justicing for similar conduct to sit on the matter of the ordinary citizen, whether it's a civil matter or a criminal prosecution, as sometimes financial misappropriation can lead to? So it seems to me difficult to retain the legitimacy of the institution and the Supreme Court as a panel to have a Chief Justice who has been removed for stated misbehavior from the position of Chief Justice as a member of the panel.
All right, let me come to Enos of Seni here. Even though I say this sounds de minimis, I remember initially when the matter came.
I make one quick comment before you move on.
Yes.
I wanted to comment. I said I wanted to comment on all of the actors. I wanted to comment on the petitioners.
Okay.
And I want to commend them both for their courage and their proactivity. I have said time and again that a constitution is an agreement between the people, their agents, and the state, and that the people who are not ready to check or question or supervise their agents are not ready to trigger for self-government. You know, it takes courage to trigger one of the weightiest and most far-reaching processes on the Constitution. And however it plays out, if you're a petitioner, you will be a hero in some quarters and a villain in others forever. It takes courage and a genuine belief in the cause to put yourself in that position. So for showing that we have such valiant ones among us, we must collectively be grateful. I do wonder, however, how they got access to all the information and evidence in their petitions. I think some of the information is such, by its nature, it should not be available to people outside of the judiciary. So I'm very curious how they came by this information. And I think I ask these questions not to cast aspersions on their motivations. You know, I'm personally unmoved by the continuous refrain of politically motivated. It's politically motivated. Very much about public life is politically motivated. The choice of a president, even a school prefect, is politically motivated.
Right. Justice Akufu says that now every judge or chief justice is fair game.
I think accountability, as I said, a constitutional order is a delegation of authority from the people to their agents. So there should be nobody who's unaccountable in that setup. The accountability mechanism should not be so weak as to make it take up 3/4 of the time of anybody in the position to be defending themselves. But there should be, at base, an understanding that you are occupying a supervised position, and you ought to report and give account when you're asked to. So I don't have a problem with the idea that the judiciary should feel accountable.
Okay.
Independence can, at its extreme, become imperviousness, which is bad. However, and this is where I think her concern is really valid, whatever the weight of this decision, it will shake at least one judge's confidence in their independence. And so while it improves the accountability of the judiciary, it may create in the judiciary some fear of interference or intervention.
All right.
And so we must intentionally take steps to reassure the judiciary that the accountability mechanisms are accountability, not persecution mechanisms.
Thank you. So, Enos of Seni, and